So good evening everybody, welcome to Bajirao IAS Academy. So we have been discussing polity important topics for mains examination. In last few classes we have discussed some important topics such as fundamental rights, directive principles of state policy. And today also we have some more important topics and they are very important for the examination. So one by one we'll try to look into all these different topics and we'll also try to discuss them in a very detailed manner so that this discussion will be helpful for your mains examination. And the first topic with which we are going to start this discussion is about fundamental rights. And like how directive principles of state policy, fundamental rights are very important for your exam, fundamental duties are also a very important component of your examination. And in fact, fundamental duties are not mentioned in the original constitution that has been approved by the Constituent Assembly. In fact, the fundamental duties were added to the Indian Constitution through the 42nd Constitutional Amendment Act in the year 1976. And fundamental duties are based on the Swaran Singh Committee recommendations. And in fact, in the Indian Constitution, the fundamental duties are added in Part 4A in Article 51A of the Indian Constitution. And in fact, there are 11 fundamental rights. And whenever you get any question on fundamental rights, so you need to start the introduction of the fundamental duties. You need to start the introduction of the fundamental duties with the article. And you could also mention the part in which the fundamental duties are mentioned in. So fundamental duties are embodied in Article 51A of the Indian Constitution. And in fact, it is said that the fundamental duties serve as an ethical and moral compass and they always guide the conscience of the individuals. And fundamental duties also reflect the obligation of the citizens towards the nation, the society and themselves and towards the others. And as I have already told you that the fundamental duties are enshrined into the Indian Constitution in Part 4A of Article 51 are based on the Swaran Singh Committee recommendations in the year 1976. And in fact, it is said that the fundamental rights and duties are correlative to each other. Right? So in fact, if you wanted to enjoy your fundamental duties, enjoy your fundamental rights, it is very important that you need to follow the obligations which are mentioned in the fundamental duties. And because of that reason, it is said that fundamental rights and fundamental duties are correlative to each other. And in this image, you could see all the fundamental duties which are mentioned in 51A of the Indian Constitution. So what are those fundamental duties? Respect for the Constitution, its ideals, to provide opportunity for and education, early childhood care education, to strive towards excellence. So all these are different fundamental duties which are enshrined in Part 4A of the Indian Constitution. So as I have already told you that these fundamental duties are not mentioned in the original Constitution that has been approved by the Constituent Assembly. And in fact, these fundamental duties are introduced through the 42nd Constitutional Amendment Act in the year 1976 when Indira Gandhi was the Prime Minister. However, in 86th Constitutional Amendment Act was also made. So this 86th Constitutional Amendment Act was made in the year 2002. So through this amendment, a new fundamental duty, that is the 11th fundamental duty, is also added to the list of the fundamental duties. And in fact, the 11th fundamental duty emphasizes on the duty or the obligation or the responsibility of the parents to provide opportunities for education to their child. And similarly, we also have Article 21A of the Indian Constitution, which is part of the fundamental rights. It talks about free and compulsory education, or it is also known as right to education, which has been enshrined into the Indian Constitution through 86th Constitutional Amendment Act. So this is the one amendment that has been made to the fundamental duties to enshrine 11th fundamental duty, that is a duty of the parents to provide education for the children. And in fact, in number of cases, the Supreme Court has also talked about the importance of the correlation between the fundamental rights and directive principles of state policy. And along with that, Supreme Court has also held that the fundamental rights and directive principles of state policy are supplementing each other and they are complementing each other. And apart from that, the fundamental rights and fundamental duties are also complementing each other. Now, complementing each other in the sense that they are correlative to each other. So without performing your duties, you cannot expect rights. So rights are the result of performance of your duties. So in this context, what is the importance of or benefits of synchronizing rights and duties that are mentioned? The fundamental rights are mentioned in part 3 of the Indian Constitution. Fundamental duties are mentioned in part 4A of the Indian Constitution. Now we'll understand what are the benefits that we have as a society, we have as a nation, by synchronizing the benefits of rights and duties. And in fact, Supreme Court a number of times held that fundamental rights and directive principles of state policy, so they actually complement each other, and in fact they also ensure a balanced social contract. Right? So social contract in the sense that every individual, they comes together and they formed a state. State protects their rights, state ensures their rights, and in return individuals also need to perform a certain duties, and that is the social contract. And in fact, both rights and duties, they complement each other, they supplement each other, so that could ensure a balanced social contract. And in fact, duties in any society remains individuals' responsibilities or a community's responsibilities, because as a community you are enjoying certain rights which are guaranteed by the Constitution, and as an individual also you are enjoying certain rights which are again guaranteed by the Constitution. So if you wanted to enjoy your fundamental rights, it is very important that you need to perform your duties. So therefore, here duties serve as a reminders of responsibilities while you enjoy your fundamental rights which are guaranteed by the Indian Constitution. And in fact, duties also immunize individual liberties and balance social capital. So when you are performing your individual duties, so that could provide immunity to your individual liberties. So you could enjoy your individual liberties, right? So that could have more legitimacy, more credibility as well. And that is very important for a balanced social capital, because as an individual, as a citizen of this country, I have certain duties and I am performing those duties. So since I am performing those duties, I deserve rights. So that is, what is called as a balanced social capital. And in fact, duties support the state in achieving the goals and also promoting the voluntary services as well. And in fact, state set various goals. So for example, eradication of poverty is a one such goal. Or apart from eradication of poverty, we have a goal of becoming Viksit Bharat by the year 2047. Now, without performing your duties, you cannot expect that you could achieve this goal by the 2047. And it is very important that every individual must perform his or her duties. So that is very important, because that makes state achieve the goals. And it also promotes the voluntary service as well. People would, individuals or communities, they come together whenever the time requires, or whenever there is a need, so the communities and individuals come together and they work for the welfare of the entire nation. And in fact, the fundamental rights and fundamental duties play a very, very important role in ensuring peace and harmony in the society. And in fact, peace and harmony in any society is very, very important. Particularly Indian society, peace and harmony is very, very important, because we have been seeing sectarian violence, we have been seeing the communal violence, and we have also seen the criminalization of politics, and we have seen human trafficking, drug abuse, organized crime networks, terrorism, radicalization, fundamentalism. So in this context, when everyone performs their respective duties, so it actually helps building a peaceful and harmonious society, and that is very, very important for a country like India, which has a huge diversity, which also has a huge challenges. And that is how, as a nation, we progress. And in fact, when we try to balance rights and duties, we always face certain challenges. It is not free from the challenges. So we also face a certain challenges. Now, what are those challenges? So it is also very important for us to understand those challenges as well. For example, when we try to balance the rights and duties, the problem here is that there is a huge difference in legal status of both fundamental rights and directive principles, because we knew that fundamental rights are enshrined in Part 3 of the Indian Constitution and they are justiciable rights. But on the other hand, the fundamental duties which are enshrined in Part 4A of the Indian Constitution, they are not justiciable in nature, similar to the directive principles of state policy. So this is one problem. For example, if any individual is not performing his or her duty, so you cannot go to court, right? So they are non-justiciable in nature. And secondly, the nature and scope of the rights, or the fundamental rights, or the fundamental duties, or sometimes we can say that they are conflicting or contradictory in nature. And this is also one of the major problem. Okay, so they are very often contradictory, most often with Article 19 of the Indian Constitution and Article 21 of the Indian Constitution. So you could mention such examples as well along with these points. So you should always try to mention examples, because examples will enrich your answer, and examples will also provide you the credibility, the legitimacy that is required. And in fact, the vagueness and subjectivity of certain duties can also cause clashes with the religious principles or even the larger societal norms as well. And in fact, the legal experts very often call certain fundamental duties are vague in nature, so they're not properly mentioned. And that is one problem here, because that could very often create clashes with religious principles and even societal norms as well. And in fact, fulfillment of certain rights may be prerequisites for the performance of one's own duties. So therefore, you should always, whenever you are fulfilling some of your rights, so a fulfillment of your rights is very important, or prerequisites for the performance of duties as well. So these are some of the conflicts. However, there are certain criticisms that the fundamental duties have been facing. Now, what are the criticisms? So we'll have a look at these fundamental duties and the criticisms as well, and how they are enforced through the legislations. For example, fundamental duties have been subject to several criticisms, such as they are non-exhaustive in nature, they're not too exhaustive, and fundamental duties also encompass unclear and ambiguous duties as well. So very often they are not clear, they are vague, and they are ambiguous as well. And in fact, fundamental duties questions about the necessity of their inclusion in the constitution, because fundamental duties are originally not part of the constitution. Rather, through 42nd Constitutional Amendment Act in the year 1976, fundamental duties are enshrined into the Indian constitution, and because of that reason, legal experts very often question the rationality of including these fundamental duties into the Indian constitution. And in fact, the fundamental duties have a marginal importance due to their positioning as an appendix to part 4 of the Indian constitution. And the other thing that we should understand here is that the fundamental duties are non-justiciable in nature. They are non-justiciable in nature. However, throughout the years, the parliament or the central government made a number of attempts to implement these fundamental duties through various legislations. So we'll understand what are those legislations that the central government has brought in to implement some of these fundamental duties. Right? So as we have already understood that these fundamental duties are non-justiciable in nature. Right? So in fact, the government has framed the Prevention of Insults to National Honours Act 1971 and the Protection of Civil Rights Act 1955. Right? So in order to protect the civil rights of the people, and Indian Penal Code 1860, Wildlife Protection Act 1972 and Forest Conservation Act 1980. So, these provisions indirectly enforce various fundamental rights. Okay, so in fact, Forest Conservation Act or Wildlife Protection Act, Indian Penal Code, so all these different legislative measures taken by the government indirectly enforce some of these fundamental rights, right? So you could also mention these legislations along with your answers, so that will make your answer more and more effective. So we have discussed about the fundamental duties, and the next a very important topic is scheduled and tribal areas. So scheduled and tribal areas is also a very, very important topic. Particularly, we will discuss about the Panchayat Extension to Scheduled Areas Act, the 5th Scheduled Areas and 6th Scheduled Areas, 6th Scheduled Areas as well as 5th Scheduled Areas. And also Panchayat Extension to the Scheduled Areas Act as well. So I hope you knew what is a 5th Scheduled Area and what is a 6th Scheduled Area. So 5th Schedule of the Indian Constitution deals with the administration and the governance of a certain areas in different states where a tribal population live. And 6th schedule specifically deals with states like Assam, Meghalaya, Tripura and Mizoram. Right? So 6th schedule specifically talks about Assam, Meghalaya, Tripura and Mizoram, and 5th schedule in general talks about the governance and administration of the tribal areas. Okay, so in fact these two schedules provide the alternate or special governance mechanisms, right? So there will be a special or alternate governance mechanism. So governance in 5th and 6th schedule areas is not similar to the governance in other parts of India, right? So therefore the 5th schedule and 6th schedule provides a special governance mechanisms for certain scheduled areas in mainland and certain tribal areas in the northeastern part of India. And in this context, so let's have a look at some commissions which are appointed by the president for looking into the conditions of the scheduled areas or scheduled tribal population. And in fact, the first commission is Debar Commission, and it was appointed in the year 1960s. Debar Commission was appointed in the year 1960s, and the second commission was appointed in 2002 under the chairmanship of Dilip Singh Bhuria. Okay, so this is the second commission under the chairmanship of Dilip Singh Bhuria, and both these commissions look into the scheduled tribes and their socio-economic conditions or scheduled areas or tribal areas. So all these different things, and also suggest appropriate reforms or appropriate suggestions. The president has appointed these two committees. And here some key constitutional provisions which specifically talks about the areas in 5th and 6th schedule. And in fact, Article 244 of the Indian Constitution. Now what Article 244 of the Indian Constitution talks about? So Article 244 of the Indian Constitution says that it has a certain provisions for the 5th schedule areas. As I have already told you that 5th schedule deals with the administration and governance of the scheduled areas. Okay, so in fact the 5th schedule shall apply to the administration and control of scheduled areas and scheduled tribes in any state other than these 4 states which are included in the 6th schedule. And in fact the 5th schedule states at present are 10 states. Now in the 5th schedule there are around 10 states. Now what are those 10 states which are included in the 5th schedule? And in fact these 10 states must have a tribal minister at the state level. For example, Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha and Rajasthan. These are the 10 states which are included in the 5th schedule of the Indian Constitution. And in fact, governor in these states also have some special powers with respect to the scheduled areas. So what are the powers that governor has with respect to the scheduled areas? And in fact, governor can actually declare any law that is not applicable for these scheduled areas, and that is the power, that is the kind of a power which has been given to the governor, whether it is a law made by the state legislature or a law made by the parliament. And in fact, so in order to extend 73rd Constitutional Amendment Act provisions to the scheduled and tribal areas, the parliament has passed Panchayat's Extension to Scheduled Areas Act in the year 1996. So therefore, the provisions of Panchayat Extension to Scheduled Areas Act 1996 is applicable to the 5th scheduled areas. And in fact, these 10 states would have a tribal advisory councils. Right? So we have just discussed these 10 states which are part of the 5th schedule of the Indian Constitution, and these 10 states would have a tribal advisory council, and they have a maximum of 20 members, of which 3/4 are ST MLAs, and it is the creation of the state legislature, and it has the advisory powers. And in fact, what is the power of the president with respect to the scheduled areas or the tribal areas? So president also has a certain powers with respect to these tribal areas, because president can actually declare an area to be scheduled area. So he or she has the power to declare a particular area in a state as a scheduled area. And in fact, president is also empowered to increase or decrease the scheduled area, alter the boundary of the scheduled area. And in fact, president can also make a fresh order for redesignation of an area in consultation with the governor of that particular state concerned. And in fact, so president also has some additional powers as well. Okay, so a president can also appoint a commission to report on the administration of the scheduled areas and welfare of the scheduled tribes in the states under Article 339 of the Indian Constitution. And using this power, which is enshrined in Article 339, President so far appointed the first Debar Commission. First commission was appointed in 1960 and second commission was appointed in 2002 under Dilip Singh Boria. And in fact, any amendment can be done without invoking Article 368 for both 5th and 6th schedules. So for both 6th and 5th schedule, so any amendment can be made by the parliament, but that amendment cannot be called as the constitutional amendment. Now, what is the criteria for declaring an area as a scheduled area? So a set of criteria has been provided, and this criteria is strictly followed to declare a particular area as a scheduled area by the president. Now, in fact, that particular area should have a preponderance of the tribal population. So the density of tribal population should be very, very high, and apart from that, the compactness and the reasonable size of that particular area. And the tribal area is underdeveloped in nature, and in fact it has a marked disparity in economic standard of the people. So this is the criteria to declare any area as a scheduled area. Now, whenever you write any answer on either 5th schedule or the 6th schedule, so you could draw a diagram and you could mention the criteria, right? So you can mention criteria like this, and you can actually mention the criteria for declaring any area as a scheduled area, right? So that will further enrich your answer. Now, in this context, we'll try to discuss the Panchayat extension to the Scheduled Areas Act. So that has been passed by the Parliament in the year 1996. So what exactly is this Panchayat extension to the Scheduled Areas Act, and how it is going to benefit the panchayats or the people who are living in scheduled and tribal areas? Now, Panchayat extension to scheduled areas has extended the provisions of Part 4 of the Indian Constitution, Part 9 of the Indian Constitution. Part 9 of the Indian Constitution deals with the panchayats, right? So in India, we have the panchayat or local self-governance system, and that has been provided constitutional status through 73rd Constitutional Amendment Act. So 73rd Constitutional Amendment has been made. So through this amendment, panchayats are being established, and it is mentioned in Part 9 of the Indian Constitution, and this PISA Act has been framed to extend the provisions of Part 9 of the Indian Constitution to the scheduled areas with certain modification. Now, we will understand what are the objectives of the Panchayat extension to the Scheduled Areas Act. So it has a set of objectives, and the first objective is the local self-governance or the self-rule to the bulk of tribal population, which has not been provided through the 73rd Constitutional Amendment Act. Remember, governor has the power to declare any law made by either state legislature or parliament invalid or not applicable to the tribal areas. So therefore, specifically, Parliament has passed this Panchayat extension to Scheduled Areas Act to provide self-rule to the bulk of the tribal population. And in fact, to have a local self-governance or village governance, and that emphasizes on participatory democracy, and along with participatory democracy, decentralization of democracy, participatory governance, because Gram Sabha is regularly conducted at the panchayat level, and Gram Sabha would be considered as a nucleus of activities, because Gram Sabha has been endowed with certain powers, particularly identification of the beneficiaries and approval for the usage of minor forest produce. And in fact, Gram Sabha has also been given power to give approval to exploit the minor mineral resources in those tribal areas. So therefore, Gram Sabha can be considered as a nucleus of activities, and this could instill the participatory democracy or democratic decentralization at the grassroots level, particularly in those areas where tribal population live. And in fact, the Panchayat extension to Scheduled Areas Act is considered as a suitable administrative framework, and this suitable administrative framework, which is consistent with the traditional practices of the people. And in fact, to safeguard and preserve the traditions, customs of the tribal communities as well. It empower panchayats at the appropriate levels with specific powers, which could be considered conducive to the tribal requirement. And in fact, it also prevent panchayats at the higher level from assuming the powers and the authority of the panchayats at the lower level of the Gram Sabha. So particularly, the Panchayat Extension to Scheduled Areas Act would endow panchayats with much needed powers, so that it would result in the participatory democracy, participatory governance, democratic decentralization, or the grassroots democracy. Right? So these are all the objectives of the Panchayat Extension to Scheduled Areas Act. Now one by one we'll try to understand the provisions of the Panchayat Extension to the Scheduled Areas as well, because it has a set of provisions, a very important provisions. And in fact, so the first provision is about the state legislation on the panchayats. And in fact, it shall be in consonance with the, for example, whenever state legislation makes any laws on panchayats, or even this Panchayat Extension to Scheduled Areas, in order to extend the provisions of Part 9 of the Indian Constitution to the tribal areas. So this act has been made keeping in mind the customary law that the tribal people already have, because whenever you go to any tribal area where people have their own customary law that they follow from generations, and this here Panchayat Extension to Scheduled Areas Act indeed in consonance with the customary law of the tribal people. And apart from that, the socio-religious practices as well. For example, a huge chunk of tribal population follow animism, right? So that is not just animism, but they have a different social and religious practices, and it is very important to protect their unique social and religious practices. So therefore this law is in consonance with their social and religious practices, traditional management practices of community resources, customs, traditions. So it would not anyway disturb or destroy the traditional cultures, customs. Right? So that is the first provision. And in fact, as we have just discussed that how Panchayat Extension to Scheduled Areas will safeguard their identity and culture. Yes, it is true that this particular act will safeguard their indigenous cultures, their existing identity. Right? So in fact, every village under this Panchayat Extension to Scheduled Areas Act will have a Gram Sabha. And Gram Sabha is also given a certain powers, right? So with those powers, Gram Sabha can effectively safeguard the customs, traditions of the people, the cultural identity, and the minor community resources that the people have, that they are getting their livelihood. So therefore, Gram Sabha has been given the pivotal position in the Panchayat Extension to the Scheduled Areas Act, and it is also expected that the Panchayat Extension to Scheduled Areas Act will also lead to the socio-economic development of the tribal populations, because now as per the existing data about the tribal people, and if you go through the data, it is being said that the people in those tribal areas, particularly women and children, so they are malnourished, and they are facing the problem of anemia or iron deficiency. And apart from that, people in these tribal areas lack connectivity, they lack access to education, lack access to healthcare. Right? So they are actually deprived of the basic necessities of life. And in this context, it is the responsibility of the government to ensure minimum level of social and economic development in those tribal areas. However, through the Panchayat Extension to the Scheduled Areas Act, it is expected that the government would also come in, and government will ensure the social and economic development, right? Because remember, as I have already told you, that Gram Sabha is a nucleus of activities, and Gram Sabha has been given various powers under this act. So therefore, Gram Sabha will meet regularly and it will approve plans, programs and projects for social and economic development, and Gram Sabha will also be responsible for the identification of beneficiaries for various government programs. For example, Mahatma Gandhi National Rural Employment Guarantee Act. So it select beneficiaries of this particular scheme. And similarly, there are number of schemes that the government has launched. So therefore, Gram Sabha will play a very important role in poverty alleviation. Poverty is very high in these tribal areas. And not just poverty alleviation, and it will also lead to the large scale social and economic development of people in the tribal areas. And apart from that, the Panchayat Extension to Scheduled Areas Act also contains the provisions for reservation of seats. Okay, so it also consists some provisions for reservation of seats. So remember, through 73rd Constitutional Amendment Act also 33% of the reservation has been given for the women in general. And apart from that, reservation for scheduled caste and scheduled tribes has also been provided through 73rd and 74th Constitutional Amendment Acts as per their population proportion. Right? So therefore, this Panchayat Extension to Scheduled Areas Act also provided reservation for the scheduled tribes. And in fact, the reservation for the scheduled tribes shall not be less than half. Right? So it shall not be less than half of the total number of seats. And further, all seats of chairperson of the panchayats at all different levels should be reserved for the scheduled tribes only. And this is the provision of reservation, and this is otherwise called as affirmative action, or this is also called as the positive discrimination by the state. Positive discrimination. Now, why this provision has been provided? So in order to correct the historical injustice that the people have been suffering, or they suffered, right? So apart from that, Gram Sabha has been endowed with certain powers with respect to the land acquisition for the projects, right? So it has also mandated consultation with the Gram Sabhas when it comes to acquisition of land in the tribal areas for the project implementation. Right? So Gram Sabha at Panchayat at the appropriate levels shall be consulted before making the acquisition of land. So they will be consulted before acquiring land. And even if the government decides to explore the mineral resources from the tribal areas where this Gram Sabha has been located, where this Panchayat has been located under this PESCA Act or PISA Act, the prior recommendation of the Gram Sabha or Panchayats at the appropriate level, so whatever level necessary, so the recommendation of the Gram Sabha shall be made mandatory for the grant of concession to exploit mineral resources in those tribal areas. Right? So, this is how the provisions have been provided under the Panchayat Extension to the Scheduled Areas Act. Now, this particular act is not free from certain issues because it has been facing a number of issues. So we'll understand what are the existing issues in the implementation of the Panchayat Extension to the Scheduled Areas. Now, any program that the government has launched, or any scheme or any legislation for the benefit of the people, it always have a certain loopholes, and the first problem is poor implementation of such programs or legislations. And in fact, this Panchayat Extension to Scheduled Areas Act is one of the act which aimed at bringing grassroots democracy to the tribal areas. But this particular act remains disempowered as 40% of the states in India have not been able to frame their rules for the implementation, right? So in whatever state that this particular legislation is going to be implemented, those states have not framed rules for the implementation of the Panchayat extension to the Scheduled Areas Act. Now, in this context, it will lead to the poor implementation of the legislation. Whatever objectives with which that particular act has been passed, those objectives will not be fulfilled when states are not interested to frame the rules for the implementation. And in fact, there are states like Chhattisgarh, Jharkhand, Madhya Pradesh, Odisha with a sizable and significant number of tribal population. They not yet framed rules for the implementation of the PISA Act. And in fact, states have their own laws, and those laws are very often inconsistent with the Panchayat extension to the Scheduled Areas Act, and that has been very often creating a lot of confusion, and it has also been creating a lot of complexities when it comes to the implementation of the Panchayat extension to the Scheduled Areas Act. Now, we have discussed that the 5th schedule deals with the scheduled areas in 10 states, and we have also discussed those 10 states as well. And all those 10 states which actually have the scheduled areas have actually amended the state acts, but they are not in consonance with the letter and spirit of the Central Panchayat extension to the Scheduled Areas Act. Now, in this context also, so you could expect that the actual benefits or the objectives of Panchayat extension to Scheduled Areas Act is not realized properly because of the existing state laws which are not in consonance with the PISA Act. And very importantly, at the state level, when it comes to the implementation of this legislation, there is a huge absence of 3 Fs. And even for that matter, in 73rd Constitutional Amendment Act and even for 74th Constitutional Amendment Act also, these 3 Fs are very often emphasized. So what are these 3 Fs? So 3F means funds, functions, and the functionaries. So these are called as 3Fs, and absence of the transfer of these 3F is one of the major problem. Is not just with respect to panchayats and municipalities in general, but this is also very common in the tribal and the scheduled areas. So in this backdrop, you cannot expect that a better implementation of this particular legislation, and it makes it very, very difficult to put the Panchayat extension to Scheduled Areas Act in operation. And apart from that, land acquisition without the consent of the Gram Sabha. Right? So land is being acquired without the consent of the Gram Sabha, and that is another major challenge or a problem here. Because we have understood that one of the provision of Panchayat extension to scheduled areas is that whenever the government has been planning to acquire land from the scheduled areas or tribal areas, so the government must consult with the relevant Gram Sabha at the appropriate level. But now the government has not been consulting with the Gram Sabhas when it comes to acquisition of land. For example, in Korba district of Chhattisgarh, the government is acquiring the land using the Coal Bearing Act of 1957. So that you could mention as an example. And in fact, so under this particular legislation, there are panchayats in scheduled areas and tribal areas. But most of the elected representatives in these panchayats are unaware about things. They are unaware about the resources that they have at their disposal. Right? And they are unaware about the powers, functions, the finances. So this has been creating a huge problem for the fair and better implementation of the Panchayat extension to Scheduled Areas Act. No doubt there are large number of elected representatives, but most of them are semi-literate or illiterate or they know very little about their roles and responsibilities, programs, procedures and systems, and that has been creating a huge problem when it comes to the implementation of this Panchayat Extension to Scheduled Areas Act. So in fact, the government has also enacted various laws, and these laws comes in conflict with the better implementation or fair implementation of the Panchayat Extension to Scheduled Areas Act at the grassroots level. For example, the Land Acquisition Act of 2013. So it has empowered the Gram Sabhas immensely. Similarly, the Forest Rights Act 2006, and it has also consists certain provisions, or it has provisions of the Panchayat's Extension to Scheduled Areas Act. So these are some of the problems that the local self-governance institutions in scheduled and tribal areas have been facing. However, some suggestions have been provided. So it is very important that whenever you write the answer, it is always advised that you should mention some suggestions as well. Now, what suggestions that you could give? So adequate training shall be provided for the elected representatives of Gram Sabha, because we have understood that most of the elected representatives are unaware about their roles and responsibilities. So therefore, you should emphasize on adequate training, and that should be given to the representatives. And similarly, legal awareness among all the primary stakeholders. So there should be a legal awareness that has to be provided among all primary stakeholders. So that must be provided for effective functioning of the Gram Sabha, so that they could be aware about their roles, their responsibilities, their rights, the powers that they have, and the procedures, how it actually works. And that would leads to the better implementation of Panchayat Extension to Scheduled Areas Act in a more letter and spirit. And even the role of women must be ensured in decision making process at the Gram Sabha, right? So women are very often considered as a change makers. So they bring change. So therefore, women role should not be undermined. Women should be given a larger role for the successful implementation of this PISA Act. And even civil society, NGOs, and other like-minded groups, they can also come and work on rights-based approach of people to protect the rights of people, the tribal population of the country. And in fact, the central government should actually direct the states to gear up the process of amendments to the existing laws, so that it follows the provisions of the PISA Act in letter and spirit. And similarly, it is desirable to amend the Indian Forest Act, the Land Acquisition Act 2013, and other related acts, so that the provisions of these legislations could be brought in consonance or brought in close with the Forest Rights Act. Okay, so particularly with respect to ownership of minor forest produce, water bodies, land resources, which are explicitly handed over to the Gram Sabha of the Panchayat Extension to Scheduled Area. So these are the suggestions that one could actually provide, right? So there are certain government initiatives also that have been launched. So we'll understand these government initiatives also, because it is also a very important topic. Now, what are the government initiatives that have been launched? For example, the Forest Rights Act 2006 has been passed, and this Forest Rights Act aims to recognize and vest forest rights in the forest dwelling tribal communities or the scheduled tribes. And secondly, the Van Bandhu Kalyan Yojana is also another scheme that has been framed by the government to benefit the tribal population. And this welfare scheme seeks to uplift the tribal people and improve the quality of tribal students' education. And similarly, the government has also, brought in Ekalavya model residential schools. And the Ekalavya model residential schools aimed to improve education infrastructure, learning outcomes for the tribal population in various schedules and tribal areas. So this is also another very important and flagship program that the government has launched. And the next topic is the 6th schedule areas. So we will also discuss about the 6th schedule areas and what is this 6th schedule and what are the important provisions of the 6th schedule. And in fact, the 6th schedule has been mentioned in Article 244 of the Indian Constitution, right? So it consists certain special provisions for 4 states. So we have just discussed what are those 4 states: Assam, Meghalaya, Tripura and Mizoram, right? So it consists of special provisions for Assam, Tripura, Mizoram and Meghalaya. Now, why there is a need for special provisions only for these 4 states? Now, in fact, tribal population in other states, they are mostly mainstreamed, right? So now they have access to healthcare, access to education, and in fact their culture is also mixed with the culture of other people. But on the other hand, there are certain tribal groups who are living in these 4 states, for example Assam. So in Assam we can talk about Karbi Anglong, and we can also talk about the Bodo land, right? So Bodo tribe, right? So Bodo tribe, Karbi Anglong or Karbi tribe. So there are certain tribes in these particular states. So in fact they have a unique culture, unique customs, unique traditions, and they are not mainstreamed yet, right? So in fact they are protecting their indigenous cultures, and they also lack the development that actually seen in other regions of the country. And because of that particular region, the government has felt the need to provide a certain autonomy to these particular tribal groups in these 4 states, so that they could actually protect their indigenous culture, the traditions, customs and their social life, and they could also achieve a substantial level of socio-economic development. And that is the objective that the 6th schedule has been included. Now, what are the features of administration in this 6th schedule areas? We'll try to understand this as well. Right, so the 6th schedule has been provided for autonomous district councils and autonomous regional councils. Autonomous district councils plus autonomous regional councils. So the autonomous district council and autonomous regional councils have provided a certain degree of autonomy when it comes to the administration and governance of those tribal areas. Right, so in fact the tribal areas in these 4 states have been constituted as autonomous districts, and each of these autonomous district will have autonomous district council and also the autonomous regional council. There will be a separate autonomous regional council and autonomous district council in these 6th schedule areas. And in fact these autonomous district councils and regional councils also enjoy a certain degree of legislative power as well, right? So because the district and regional councils can actually make laws on certain specified matters, right? So the power has been given for them to make laws on certain specified matters like land, forests, canal, water, shifting cultivation, village administration, inheritance of property, marriage and diverse social customs in all these different areas. So they enjoy a certain degree of the legislative power. Right, so these are the 6th schedule areas. Now, apart from the legislative power, apart from constituting the autonomous district councils, autonomous regional councils, they also have a regulatory power. Now, what sort of a regulatory power that they actually enjoy, that they actually have in this context? And in fact, district council can establish or construct, manage the primary schools, dispensaries, markets at the district level. right? So it is also very important that whenever a certain degree of autonomy has been given, so it is also important that you give them the legislative power, you give them the regulatory power, so that they could actually oversee the development of those tribal areas. And in fact, the autonomous district councils or autonomous regional councils, they can also make regulations for control of money laundering in those areas, trading by non-tribal people who are coming and trading in those areas. And they can also, but these regulations actually require the assent of the governor of that particular state. Okay, so in fact, the taxation power, they also have a certain taxation powers as well. So what sort of a taxation power they have? So taxation power in the sense that the district and regional councils are actually empowered to assess and also collect land revenue, and they could also impose a certain specified taxes on certain activities that are carried out in the district. And in fact, the acts which are passed by the state legislature or the parliament do not apply to the autonomous districts or even the autonomous regions as well, or they could also be applied with the specific modifications or specific exceptions to these areas. And in fact, there's also a provision for the appointment of a commission as well. Now, in this context, the responsibility of appointment of a commission is given to a governor. Governor can actually appoint a commission to examine and also report on any matter relating to the administration of the autonomous districts and also the regions as well. Right? So these are the powers that they actually enjoy. However, they have a certain issues and they also have the challenges. Now, what are the issues and the challenges that the 6th schedule areas have been facing? The 6th schedule areas lack the required financial autonomy. The necessary amount of the financial autonomy is lacking. So this is one of the serious limitation that they have been facing, because they're very often dependent on the transfers from the central government or the state government, but they lack the financial autonomy to impose taxes, to collect the taxes, to raise taxes on their own, right? So when they are financially autonomous, so they could better spend that particular amount of money or resources for the development of these tribal areas. And that is very important because these tribal areas are considered as the backward areas. And this is considered as one of a very serious limitation. Because, the fact of the matter is here, the powers are given to the councils to make a legislation and also implement developmental programs. But whatever powers that they have been given for, to make a legislation or to implement the developmental programs, so those powers are actually not matching with the financial resources that they actually have or financial autonomy that they enjoy. And that's where it actually creates a contradiction. That's where it actually creates a problem for these councils. And in fact, more than required powers have been given to the governors as well. And this is also another major problem that they have been facing, right? A considerable powers have been handed over to the governor in the 6th schedule areas, and that can actually impede the functioning of these autonomous district councils. And that is one of the major problem. So therefore, powers here should be rationalized, and that is very important. Rationalization of powers would ensure that no single authority would have, a huge power concentrated in that particular authority. And similarly, there are different district councils, autonomous district councils in these 4 states. But the problem is that these different district autonomous councils or regional council for that matter have a variation in powers, and all these regional councils or district councils have no similar powers, and that is also another major problem, right? So in fact, the Bodoland Territorial Council, it has a more power and the departments compared to the other autonomous councils of the Northeast. For example, the Karbi Anglong Autonomous Council. So it has a less powers compared to the Bodoland Territorial Council. For example, the Dima Hasavo, council, regional council, or the district council. So it is having more powers or less powers. So therefore, the situation has resulted in other areas which are coming up, and they are also demanding that more powers and should be given to us. More departments should be provided to us. So these are some of the demands that are increasing. And even elections are also indefinitely postponed. Right? So there is also no mandatory time limit for the reconstitution of the autonomous district councils. So once this autonomous district council is dissolved, and hence the election is indefinitely postponed, and that is also another major challenge. So whenever there's no mandatory time has been provided for conducting elections for these councils, of course there is a very high chance that the elections may not be conducted, because it could serve the vested interests of certain political parties. And in fact, women's participation is not up to the mark, and small tribal groups which are living in that particular tribal area's participation is also very, very inadequate. Right? So there are absence of provisions for women and often the smaller tribal groups in these tribal councils is also very less. So therefore, there should be provisions that have to be provided in this context. So what should be the way forward, right? So we should also discuss the way forward as well. So the way forward would be women should actually be given reservations, because we have just understood that the 73rd and 74th Constitutional Amendment Acts have been provided 33% reservation for women. And similarly, recently 106th Constitutional Amendment Act, so that talks about Nari Shakti Vandana Abhiyan. So that also provides 33% of reservation for women in the Lok Sabha and State Legislative Assembly. So therefore, in order to substantially increase the participation of women in autonomous district councils, autonomous regional councils, reservation should be provided for women. A certain proportion of seats should be reserved for women. Right? So therefore, it actually makes more and more women participation in the tribal councils, or autonomous district councils or autonomous regional councils. Otherwise, it could lead to the exclusion of women from these political institutions. And there should be a mandatory provision for the participation, or a mandatory provision for more and more representation for the small tribal groups which are living within that particular area as well. And funding, so they should be given more financial autonomy. So autonomous councils must be covered under the State Finance Commission, and funding to these councils should not be left to arbitrary discretion of the state governments, and that could be very, very problematic. And similarly, timely election. So the autonomous district council should be reconstituted within 6 months of its dissolution. Right? Because as of now, there's no time limit and elections are not held properly. So therefore, this also creates new problems. And small tribal groups reservation. So when we talk about the small tribal groups reservation, because there's an inadequate participation of women and also small tribal groups in these councils, autonomous district councils and autonomous regional councils. So therefore, there should be a provision for a smaller tribal groups in the autonomous district councils and other political institutions. And in fact, when we talk about the traditional political institutions, so there is a need for such a traditional political institutions at the village or hamlet level. So they should be formally recognized by the state government as well, and that is also very, very important for participatory democracy, grassroots level democracy, or even the democratic decentralization at the village level as well. So ultimately, in conclusion, what you could write, so factors such as land alienation, displacement, and even poor implementation of the vulnerable schemes actually underscores the necessity of proactive measures, right? So those proactive measures could actually improve the socio-economic situation of people who are living in these tribal areas. However, a multi-stakeholder approach is required that should involve the government, judiciary, civil society. So they must work collaboratively, right? So when they start working collaboratively, so that would help achieve the objective of ensuring that India's cultural mosaic continues to thrive, right? So that's how we could actually make the 5th schedule and 6th schedule areas more and more empowered, right? So they could be made more and more inclusive, and that is very, very important. And that's all in this lecture, and thank you so much. In our next class we will have a few more topics, right? Thank you.